Whilst the International Labour Organization is convening its 111th conference in Geneva as we currently speak, CDH is truly honoured to host from Johannesburg, South Africa, the Commission for Conciliation, Mediation and Arbitration, which we know to be a world-acclaimed dispute resolution agency within the world of work, on a discussion of its April 2023 amendments to its rules of proceedings. Now, very recently, we were seeing in the press that the CCMA National Director, as well as the Judge President of the Labour Appeal Court, who quoted discussing the various backlogs that are being experienced both at the level of the CCMA as well as in the Labour Court. Hopefully, the new rules which are going to be discussed today are almost a step closer to assisting to unblock these massive case rolls which are being experienced by the CCMA with the advent of COVID and the numbers of disputes that have come through the system over that period and also in very difficult economic times. Today, we're proud to introduce 3 senior commissioners of the CCMA, one based in Gqeberha and 2 others from the head office in Johannesburg. It's Antonio Budali, Laurie Warwick, and known to us is Peter Venter. Antonio obtained his LLB and his master's at the Nelson Mandela University, and is also a non-practicing attorney, fortunately for no sins on his part. From 2008 until 2013, Antonio worked as a part-time lecturer at Nelson Mandela University, and it was also during this time that he worked as a part-time commissioner at the CCMA. In 2015, Antonio became a full-time commissioner, and in 2021 was also appointed as the acting senior commissioner of operations at the national office. That's an acclaimed position for senior commissioner at the CCMA. He's now currently the regional senior commissioner of the Gqeberha office in the Eastern Cape. Laurie Warwick is currently registered for an LLD in law at the University of Stellenbosch with a very interesting doctoral thesis with the particular topic of the dissemination of the principles of individual labour law through codes of good practice. I certainly look forward to reading this dissertation, and it's an aspect of both our individual labour law as well as collective labour law, I would suggest, that comes out quite often and to determine where the lines are in relation to the law and codes of good practice. Laurie, unlike the rest of us, had the great fortune of not only studying law, she's got vast experiences outside of the legal fraternity, in respect of aspects like social work and something that's very important in the world of the CCMA relating to social justice. Laurie is an LLB and has acted as an arbitrator, conciliator, and facilitator of the CCMA. Interestingly, Laurie also comes with the experience of a case management officer, someone we are all very familiar with. So Laurie's got the experience of having her hands dirty in relation to how matters actually play out in the CCMA. A job of a CCMA CMO, as we all know, being very important in the administration of a matter from inception to its end. Currently, she's a senior commissioner in the training material development unit of the CCMA, based in Johannesburg, and is very, very involved in the CCMA delivery in partnership with the various universities in respect of building capacity and graduate qualifications within the CCMA. Lastly, I'm proud to introduce Peter Venter, who's also senior commissioner and currently the manager employee relations and engagement at the CCMA. Now, Peter is an admitted advocate and has practiced many years as a counsel with the Free State Advocates Society. Peter started as a part-time commissioner in 2006 and has for numerous years served in this portfolio for the CCMA as well as various bargaining councils across the country. Peter was previously employed by the Department of Correctional Services as well as the Public Service Association and has acted as a judge in the Labour Court on a pro bono basis on various occasions. Peter was also the chairperson of the CCMA's Rule Task Team, so he's the right sort of person to have in this discussion of today. Now, here's a confession. I don't have a YouTube channel. I've always wanted to say that. If you've got questions, drop them in the comment section below. I'm pleased to say I'm not going to answer any of them. Our illustrious panel will take the questions and respond to them in the comments as they go along, and have also agreed to pick up questions at the end of the session. On that basis, I'm pleased to present Antonio Woodley, who's our first presenter.
Thank you, Imran, for those really kind words. And on behalf of the CCMA, I would like to thank CDH as well for allowing the CCMA to present on this platform and to present especially to the wider audience and not only your clients on that note as well. And I think that with the rules coming out, it's important that as a CCMA and with all our social partners, our stakeholders, that we engage the public, that we ensure that people are aware of the rules, they are knowledgeable about the rules, and they have this so that we don't have a situation where 6 months down the line that we meet someone that comes to the CCMA and he says, I've never been aware that the rules has been changed. We need to ensure that we get on with these advocacy campaigns to ensure that we create that awareness for the public. I think that is our duty as stakeholders of the CCMA as well as the CCMA itself. If we can just maybe go to the first slide. Thank you for that, Andre. As Imran has mentioned, myself, Senior Commissioner Venter, and Senior Commissioner Warwick will be going through this presentation. It's about 52 slides, and we've each going to be dealing with a third of the slides. I'm going to start with the first, with the introduction. We're going to give a brief background of the rules, where it comes from, what has been changed. We're then going to go into the general updates of the rules and the forms, and as well as an overview of the key amendments to the rules and the forms. And that would obviously be dealt with by myself and my senior commissioner colleagues as well. Go to the next slide. Thanks, Andre. Just a brief background. Why do we need to create rules, and why does the rules have to be changed every 2 years? Now, in terms of Section 115 of the Labour Relations Act, the CCMA as an organization, as a public institution, is empowered to create rules to regulate its own processes. Section 115(1)(e) also allows the CCMA the discretion to amend those rules every 2 years. The current rules amendments start in 2021, and it culminated in the amendments that took place in April this year. When the rules are amended, there is quite a lengthy process that is involved prior to the rules being published in the Gazette. And as Imran has mentioned earlier, Commissioner Peter Venter, he's one of the senior commissioners. He's also the head of the task team that was appointed by the director to basically deal with the amendments to the rules. Myself and Senior Commissioner Warwick are also part of that task team. So we are part of the task team, and we will then investigate all amendments that happened in law, whether it's via legislation, whether it's via case law. We'll look at the amendments. We will then put together an amended set of rules that will go through a vigorous process of engagement with stakeholders, including unions, employers, before it goes to the governing body for approval. Once that process is completed and it gets gazetted, then we have the new rules. In 2 years' time, of course, we will be sitting here again, and we will obviously deal with the new amended rules as per Section 115(1)(e) of the LRA. You can move to the next slide. Thanks, Andre. Just to begin with, one of the many amendments we made to the rules is that we've dealt with typographical errors, changed the name of cities that have now been changed in the last 2 years. Grahamstown in the Eastern Cape has been changed to Makonda. Port Elizabeth, where I am from, has been changed to Kabega. Nelspruit to Mbombela. The Department of Labour, as we know it, has been amended to the Department of Employment and Labour. We've also inserted the official CCMA electronic referral online portal into our rules. Now, this is a new method that parties have to defer disputes to the CCMA. And it's something that we are trying to encourage parties to do. As you know, with the 4IR, things are moving at quite a fast pace. 2 years ago, before COVID, we never had so many Teams meetings, as we have today. We didn't have as many virtual sessions as we have today. So in the last 2 years, the amount of improvement, that has taken place in light of our 4IR, in light of COVID, has resulted in us having to change the way we operate. And the CCMA as an institution, as a public institution, also had to amend its ways in which it operates. And one of the ways that we amended is that we've included a way to refer matters to the CCMA via an online portal where a user doesn't have to come physically to our offices to refer a dispute. A user can sit on his bed at home, wherever they are, overseas, London, America, and from wherever they are, they can refer a dispute to the CCMA. So that's where we are as an organization. And we want to move towards a paperless society, whereby we don't have physical case files. Everything will be online. And that is where we want to go to as the CCMA. So, but as a starting point, we're introducing the online referral portal, and we encourage users to adopt that approach. We've also removed telefax numbers from ways in which you can file documents at the CCMA. We've updated the email addresses and the physical addresses of our various offices. We've removed some emails that are redundant. Where offices have changed over the last few years to new premises, we've updated those addresses as well. So then that's all contained in Schedule 1 of the Act. We've inserted POPI disclaimers in all our forms, in our tenure registers, in our rules as well. And I'm not going to go into depth in relation to POPI, and maybe I'm not sure if Senior Commissioner Warwick would like to add on to this, but with POPI, we are a public institution, and we have information that is private and confidential. We also need to be compliant with the POPI Act, which includes safeguarding that information that comes to the CCMA. As an employee as well, when he refers matter, they need to safeguard the information. They need to be in compliance with the POPI Act. And the reason that we've included these clauses in the reforms, in the rules, is to be in compliance with the POPI Act. You can move to the next slide. Thanks. So let's start with Rule 1. That's, how to contact the Commission. And it's important to note the heading of this rule. How does one contact the Commission? We are not talking about how do you file documents with the CCMA? How do you serve documents on the CCMA? The rule speaks about if I want to query something at the CCMA, if I want to go to one of the offices of the CCMA, how do I contact that office? How do I contact the CCMA? Now, this is the reason why we've removed sub-rule 2, which dealt with documents that may be filed, because this Rule 1 does not talk about how to file documents with the CCMA. It talks about how does one contact the Commission. And the Commission can be contacted and all the telephone numbers which have been updated, at all the email addresses which have also been updated, or officer of the CCMA as listed in Schedule 1. So if you have a dispute, or if you want to query something and you live in Gqeberha, go to Schedule 1, the details of the Gqeberha office, the email address, the office number, will all be included in Schedule 1 if you want to contact the office for whatever query you have. Thank you. Go to the next slide. Rule 1A, as I mentioned before, is the POPI clause. The POPI clause has been included in all our forms and our rules. And I'm not going to go into the POPI clause because the reason for today's presentation is to deal with the rules. So let's leave the POPI legislation aside, but just keep in mind that we are POPI compliant. We've included the clauses in our rules because we have to comply with legislation. Thank you. Next slide, please. Rule 2, when are the offices, when are the offices of the CCMA open? Now, this rule sets out when are the offices of the CCMA physically open and how referrals and documents may be filed after working hours. So if you want to physically take your referral form, let's say you've been dismissed. You've been dismissed today, 5th of June. You want to take your referral form to the CCMA. physically, because you don't have access to a cell phone, you don't have access to the internet, or to the online portal. You need to go to the office of the CCMA within that time period. 8:30 to 4:30, Monday to Friday. We are not open on a public holiday. We're not open on a Saturday. We're not open on a Sunday. So if you want to file something with the CCMA, if you want to go and deliver something at the CCMA physically, you need to do it during that time period. However, if you want to refer something via the online portal, via email, there's no need that you have to do it Monday to Friday, 8:30 to 4:30. So even though there might be no personnel at the office, if you email a referral form to the CCMA on a Saturday, on a Sunday, that is the day that we receive it. Thank you. So rule 3, how does one calculate the time periods in these rules? Now, before we deal with rule 3, just take note, there's a difference in time periods calculated in terms of the Act of the Labour Relations Act, that is, in a sense, guided by the Interpretation Act, and there's a difference in the time periods that is calculated in terms of these rules. So, under the old rules, or prior to April, the period between the 16th of December and the 7th of January was excluded when calculating time periods. But again, keep note, this is the time periods in terms of the rules, not in terms of the Act. So if your last day fell anywhere between that period, 16th of December to the 7th of January, the last day would automatically then be the 8th of January, because that is seen as the shut-on period. However, if it's a 711 referral form, that is not guided by the rules. That time period is calculated in terms of the Act, in terms of legislation. So that 30 days ends on if that 30 days ends on the 20th of December, that's the 30th day. It doesn't move up to the 8th of January. So what the CCMA, sorry, if we just go back to the previous slide. So what the CCMA has done, the CCMA has removed that period, 16th of December to the 7th of January. Remember, the CCMA has always been open. Whether it is 5 years ago, last year, we've always been open throughout December and January. We might not always schedule cases, but we've always remained open. The only effect that this clause had is that when you're dealing with time periods, you don't calculate that period. However, with the new rules that's been amended, we've removed that period. So when you're trying to calculate, when you're calculating your time periods in terms of the rules, you will have to include that period 16th to 7th of January. So if your last day to refer something in terms of the rules ends on the 20th of December, under the new rules, the 20th of December is the last day. Unlike in the previous rules, it would be on the 8th of January. Okay, thank you, Andre. Can move on. Then we come to Rule 4. Rule 4 is one of the, I would say, the major amendments to the rules. Now, Rule 4 has been amended in line with case law, in particular the Adams case. So, say for instance, you have an applicant who refers a dispute to the CCMA, and he does not sign his referral form. Is that referral form invalid? Is it defective? Do we process the form? What do we do? In terms of the amended rules, we process that form. It's a valid referral. However, we need to confirm that that referral form was actually authorized by that applicant, whether it is through one of our CMO officers, whether it's through the commissioner himself contacting the parties, the applicant. But the mere fact that the form is not signed by the applicant does not mean that form is invalid. And the same applies if the form was signed by someone who is not authorized in terms of Rule 25, which was the case in the Adams case. Does it mean that the referral form was invalid? No. So the general rule is when you refer something to the CCMA, that form should be signed. However, if it is not signed, or it is signed by someone who is not authorized to do so in terms of Rule 25, that referral form is still valid. That document is still valid. The condition, however, is that when one needs to confirm in the proceedings or before the proceedings that the applicant actually wants to pursue the matter. And that needs to be placed on record. Thank you, Andre. Move on. Now we come to Rule 7. As we mentioned before, we've removed telefax transmissions to the CCMA. Now keep in mind, if you want to file documents with the CCMA, you cannot use a telefax. You cannot fax anything to the CCMA. If you do so, it will not be seen as a valid filing of documents with the CCMA. However, it does not prevent parties amongst themselves to serve documents via fax to each other. So the CCMA is not going to get involved in how you as a party want to serve documents on the other party. If you need to do it via fax, you can still do so. However, when it comes to filing with the CCMA, with the Commission, we do not accept faxes as a valid form of filing. And there's various reasons for this, which I'm not going to go into, but it's a cost factor and it's a reliability factor. Sometimes an employee or an employer might fax a 10-page document, referral form, but when it comes out on the CCMA side, it's only 5 pages and the other 5 are blank. How do we prove that it was actually properly served or properly filed? Now, as a result of this unreliability, as a result of the cost implications, knowing that under 1% of our referrals are via fax, the CCMA decided to remove faxes as a way of filing with the CCMA. But it doesn't prevent, as I said, parties from serving each other via fax. Then we go to the electronic referral online portals. As I've mentioned in the beginning, I encourage users to utilize this portal. Not only is it more accurate, your matter will be processed at a more expedient manner. It's also, there's less data integrity issues that could plague that referral. So whatever data that you input into that form, that online portal, that will be sent to the other party. So if you want to refer a dispute to the CCMA, you log into the CCMA's online portal, you fill in the details, you click in, this is the employer, this is the employee details, ensure that you put the correct email addresses of the employer, you put the correct dispute, you keep a summary, you type it out, and you click submit. That automatically sends the referral to the employer. Much easier. There's issues of referrals possibly getting lost in translation, emails not being received, or like before faxes, we receive blank faxes. So utilize online portal, you'll get a reference number and you can keep track of where your referral is. Thank you. Rule 8, there wasn't, any substantial amendment to Rule 8, with the exception of we amended the name to be more in line with the meaning of this rule, which is a presumption as when service was done by registered post. And as we know, that if you serve something via registered post, it's presumed to have been received on 7 days. Okay, we can move on. Rule 9, how to seek condonation for referral documents or applications delivered late. Now, the amendments to this Rule 9 is in relation to that now it covers all employment law, not just LRA. It applies to the LRA, the BCA, the Employment Equity Act. All employment law is covered under Rule 9 in respect of if you want to apply for condonation. Now, a party must apply for condonation in terms of Rule 31. Condonation will also be applied for use in the Electronic Communication Commission Electronic Referral Online Portal, as listed in Schedule 1, but I've mentioned previously. So you don't always have to apply for condemnation and attach it to your referral form. You don't have to do it physically in terms of Rule 31. You can log onto the online portal and you can apply for condemnation if your referral has been submitted late. One, thank you. Rule 10. How does one refer a dispute to the CCMA for conciliation? Now, a party must refer a dispute to the CCMA by delivering a completed 711 form, which may include the electronic online portal. So this is one of, again, as I mentioned before, you can refer matters via the online portal. And when you refer matter to the CCMA, you must attach proof of service, which is subsection 2A, and you must attach a referral document or condemnation application if applicable. However, and this is where the important amendment comes in subsection 3, despite the above, where a referral has been deferred out of time and condemnation has not been attached to the referral, the Commission will decide whether the condemnation will be determined at a hearing or by written submissions received from the parties. Now, what this is actually saying, in the normal course of events, when you refer matter to the CCMA, you have specific time periods. If it's a dismissal case, you have to refer it within 30 days. If it's an unfair labor practice, within 90 days. If it's a request for arbitration, within 90 days as well. EA matters, 6 months. And if you refer that matter outside of that prescribed time periods, you would have to apply for condemnation. So you have various options. You can either attach the condemnation, which is generally what you should do, attach the condemnation to the referral form. But if you don't attach to the referral form and your matter is out of time, it's not necessarily going to be that we're going to issue you with a defective letter and say, I'm sorry, we're going to put your matter aside and we're going to wait for you to eventually apply for condemnation. We can deal with the condemnation at the hearing, or you can make an application. We can direct you to make an application in terms of Rule 31 and apply for condemnation. Or go into the online portal, do it there. So matters won't necessarily always be seen as defective merely because you don't have a condemnation attached to your referral form. The Act talks about dealing with condemnation, and it says condemnation can be, shown on good cause can be shown at any time. And we want to also increase the access to justice of the employees, of the parties. Let's not deal with the technicalities to say that, okay, fine, there's a referral form, it's out of time, there's no condemnation. Let us deal with the condemnation, whether it's at the hearing. Let's not prolong the matter unnecessarily. Thank you. Rule 12 deals with what we call the pre-con process. Now, a pre-con process is we call it the pre-conciliation process, is where an official of the CCMA, who is not necessarily a commissioner, would conduct a so-called telephonic conciliation or pre-conciliation prior to the matter being scheduled. What we've amended here is just the name to be more in line with that of the Act, where it says that one can attempt to resolve a dispute prior to the conciliation. So do not be surprised when you receive a phone call from an interpreter or a CMO or even a commissioner prior to a matter being scheduled, asking or seeking to resolve the dispute. They will attempt to resolve the dispute. They will phone both parties. They will ask what the offer is. They will guide the parties to come to a form of a settlement if possible. That is called a pre-conciliation process, and it can be conducted by any official of the CCMA. However, it is normally overseen by a commissioner. Thank you. Rule 13. What happens if a party fails to attend at conciliation? If a party fails to attend, and we've obviously removed who has deferred a dispute, as fails to attend at the conciliation, if it's a normal dismissal, we will issue a certificate of non-resolution. However, when it involves a mutual interest matter, then in terms of the Act, we cannot just issue a certificate. We need to also issue collection rules with that. So we've just included in this rule, under Rule 1A, that in the event that the dispute relates to a matter of mutual interest in terms of Section 64, we must determine picking rules prior or at the same time as issuing the certificate of non-resolution. And this is just to be in compliance with the Act. Thank you, Andre. You can move on. And then we come to the last rule that I will be dealing with, is how to request arbitration to the Commission. And this flows, in a sense, is the same as how to defer matters to the CCMA or 711 to the CCMA. In order for that referral to be valid, it needs to have proof of service in terms of obviously 18(2)(a), and there needs to be an application for condonation if it is referred outside of time, which is 90 days. However, if the application or the request for arbitration does not include a condonation and you're outside of the 90 days, it doesn't mean it is invalid. Because in 18 sub-rule 3, despite 18(2)(b) above, where the request has been made outside of time and if condonation has not been attached to the request, the Commission will decide whether the condonation will either be determined at a hearing or by written submissions received from the parties. So it doesn't end there if condonation is not attached to the request or to the referral. And that's it from me. Thank you, everyone. I'm now going to hand over to my colleague, Senior Commissioner Laurie Warwick. Thank you.
Great, thanks, Antonio. And I can't see anybody out there, but it's nice to be with you in any case, and warm greetings to you from a very cold Cape Town. And that's where I'm based, not Johannesburg. I'm from the land of the Stormers, for those of you who watch the rugby. So I just can't see the slides at the moment. I just wonder if there we go. All right. Yeah, so Rule 20 doesn't, there's not a lot of changes here. It's just minor things. But I thought I'd just take the opportunity to really try and encourage you to use the pre-arbitration conference facilities or the process, because it really does help us to narrow the issues down and to shorten the time period for an arbitration hearing. In fact, for those, if they're commissioners watching now, we are busy finalizing the new arbitration award template, and the conducting of a pre-arbitration conference or narrowing the issues down really will help you when you write your awards. You'll spend far less time doing so. So this just to let you know. So these changes are tiny. Just by change, it really just shows our new organizational structure. We don't have a convening senior commissioner anymore. We're now provincial, or like Antonio is regional, etc. And there were a few typos which we fixed up. So if you can go to the next one, thanks. Right, now here comes a bigger change. Now, postponing an arbitration, and this is what was referred to earlier about backlogs. So backlogs are something we don't like. Backlogs mean money. They mean you're waiting. Small businesses are not getting their matters finished. Employees aren't getting any closure. So we needed to look at the postponement rule a little bit more carefully. And one of the areas was to help all of you, if there is a genuine request or need for postponement, that you don't need to get a written agreement to postpone. So Peter and myself, or myself and Antonio, we don't need to get one document where we both sign on the same thing saying, please, 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 we agree to postpone. It can just be written confirmation. So the case management officer can phone each one if they get it in just to confirm that they've got it in writing, and just make sure that that's in the way it is. So there are the two ways. So there's the one of obviously getting that confirmation, and then the other one is on applications. So where Antonio and I say, no agreement here, I can still apply for postponement. However, it doesn't mean I'm going to get my matter postponed. All right, so that's the thing. In fact, the change to Rule 2, and I think for those of you who are very familiar with Rule 2, where you would simply need both parties to get agreement within 7 days of the arbitration, and voila, there was your matter was postponed. That's been taken away, and it was taken away because of abuse. So we'd get the same poor matter going on and on and on and on. And every time, 7 days before a postponement agreement was concluded, and the matter doesn't come to finality. So those days are over. So the idea now is that we may postpone if the parties confirm in writing that they agree to postponement. And if that confirmation was received within 7 days prior to the hearing or the date of the arbitration. You can just go to the next thing. So this is just to re-emphasize that 23.2 removes that automatic right to postponement that arose. So that's just to rub it in, if I can put it that way, or just to emphasize it. You can go to the next one. All right, so there's also the flexibility now. So in the past, with sub-rule 4, it said, after considering the written application, the Commission may, without convening a hearing, postpone the matter. But it didn't say that we could, without hearing the matter, we could consider not postponing it. So it's just to bring in that flexibility so that we don't drag things on. And then the other change then was that we could say that we can determine it in any manner that the Commission deems fit, because you might be in a hearing already, there may not have been an application, etc., etc. So that gives a bit of flexibility. And the last one, please take note of this one. If you've applied, if you've or requested or agreed or confirmed to postpone, please don't assume that that's it. You've got postponement. It's until we've actually agreed to it, and there's some sort of agreement or notification from the CCMA or the Commission that matter hasn't been postponed. So please don't pack all your books away. Keep them in that bag and put your lunchbox in as well, because you might need to be there as quick as that. All right, so that's that one in terms of postponement. And then where a hearing will take place. So here we've actually now included online venues as one of the options for hearings. So it's no longer the requirements that we all need to have agreement from this one and agreement from that one. However, we're not going to be unfair about this, because there's no point in getting someone to do an online hearing if they haven't got online facilities. That's just not going to work. So we at the moment are busy working on a pilot project as well for our, what we call it, our e-commissioner platform. So very soon you'll be receiving notification, and we'll be inviting those who are interested into user forums where we're going to demonstrate our new e-referral, e-commissioner platform. It's going to be very nice. You'll be able to upload documents straight onto the system. And obviously then you can sit in the comfort of your home if you've got electricity, and you'll be able to do your hearing. But like I say, the whole issue of accessibility and social justice does have its impact here. So if one party can, for example, be online, but perhaps the other one wasn't, we will either accommodate the other person by allowing them to come in, or we'll figure something out that is fair to both sides. So just to keep you alerted to that. And I think it'll make many people happy that you don't have to go and drive all the way to your nearest office if there are these other facilities available. Thank you. And then my last one for now, let me just see if I'm right in saying that. Yep, I'll come back again just now. So disclosure of documents or material that is relevant to the dispute. So here the change that's come in is, there was just a little snag, because in the past it said at any time after the request for arbitration, but not less than 14 days. Now, some people wouldn't understand that, but you get con arbs, etc., where you might not need to apply for arbitration. But you get those who will argue the point and say, but Commissioner, there was no request for arbitration. So we just said at any time after the certificate of outcome is issued or the expiry of the 30 days conciliation period, but not less than 14 days prior to the hearing date, either party may, on application, request the other party to disclose documents or material relevant to the dispute. So this is just to tighten that one up. And of course, you can agree. You don't need to go for all this bother if you've already agreed to share your documents. And then we also say that if there's no agreement, if Antonio and I simply just don't agree, and I now need to apply, I'll make my application. I've got 5 days, and then Antonio's got 5 days then to respond to me, and then I can also reply again. And just as another important thing is we're taking away the burden of being burdened. So we're now saying it doesn't always have to be going to the poor policeman and getting a commissioner of oath sign it via affidavit. It can now just be a written statement, because when you come to the hearing, that's where we can actually to verify if this is indeed what you had intended to write. So if there's any doubt, and I know that this will make some people happy and perhaps others will be a little nervous, but the commissioner is always going to have discretion. So if they think something is going wrong here, they will be able to put the person under oath for affirmation and sort that part out. So that's the other part then. And then we just wanted to say, and this one might be a little confusing, the last one there, sub-rule 5, is that please distinguish this rule from a disclosure of information dispute that comes in terms of section 16 of the Act. And the reason why we put it in here is that people often want to try and use section 16 when it's not a matter related to a union and a company and disclosure of information. So that simply was put in there to say it's not, if you're coming for the sort of documents that you need for your arbitration, please use this rule. Don't go and make another application in terms of section 16 for this sort of thing. So I think that's the end of Rule 29. And let me just see, I think so. Yep, that's me for now. And then I'll hand over to my distinguished colleague in the Free State province, Peter Fenton, and I'll be back just after him. Thank you. Peter, you're muted.
Good afternoon, viewers. I hear Laurie complained about it being cold in the Western Cape. So I challenge her to join us here in the Free State tomorrow. Anyway, colleagues, if the slide can, we're on Rule 30. I think just quickly before I go to the slides, if I explain the context of the amendments to Rule 30, 32, and then back to 31C, you might understand or have a better understanding of the amendments that we published in the Government Gazette. Now, I think most of you will recall approximately 2 years ago, there was a decided case of Judge Botswana in the Labour Court of Solomons versus Bokela, or we also call it the Food Lovers case. And that matter is also the case that gave rise to a large extent to the issues around postponement, because in that matter, parties actually agreed to a postponement, but the Commission did not postpone because there was no written agreement between them. So eventually this matter landed in the Labour Court, and the judge was of opinion that the CCMA can no longer dismiss matters in the true sense of the word, and the judge gave various reasons for that, which I'm not going to deal with. So that gave rise to the CCMA and our director then issuing directives, I think in October 2021, and the decision was taken that we must adhere to the Labour Court in any event, but we've decided we're not going to apply for leave to appeal, and we followed the Solomons case to the letter, and we embarked on the entire process, made a 180-degree turnaround, and decided that a commission can no longer dismiss a matter if the applicant is absent and the matter had to be removed from the roll. Now, with the directive came certain documents that we issued, which included, after it was removed from the roll, that also a document where an applicant could request a re-enrollment. And that was the rationale behind Rule 31C, which I will get to shortly. Now, lo and behold, after the rules were published and gazetted on 21 April with a date of 24 April, the Labour Appeal Court now issued a judgment in the case of Mohube versus the CCMA and others, which the employer was Praza. Now, in that matter, the Judge President, J.P. Wagley, then decided, but Solomons is not good in law, and we should not follow Solomons. If a referring party is absent, we must dismiss in terms of 138.5, I think it's A. So all in all, almost 2 years down the line, and we're back to square one, if I can use that term. And the Rule 31C is, I think, the rule that was the shortest lived rule in the history of the CCMA, because it was on our books for approximately a month. So just to give you some background, so in essence, what I'm trying to say is previously cases were dismissed, then we had to remove matters from the roll, and now from 18 May, we are back to a matter should be dismissed if referring party is not there. So if I then have a look at the slide at the Rule 30, what happens if a party fails to attend arbitration proceedings? I think what is important, what we did change in Rule 31 is that a commissioner must not just simply dismiss. There's now an onus on the commissioner to do more than that. In other words, the commissioner must go determine where is this employee or the referring party, make a phone call, check the file, check the CMS, is there no postponement, etc. So we've built in the rider that before you, we did it for removal from the roll, but it's still now there for dismissal. So before dismissing a matter, the commissioner must do something extra than just to dismiss the matter. So Rule 30 is back in the form it used to be, absent equals dismissal once the commissioner is satisfied and he took the necessary steps. So if you can go down with the slide to the next slide, please. Yeah, you can still skip this one. All right, this slide just gives you the case reference of Muhube versus the CCMA and others. Like I said, this is the decision of the Labour Appeal Court, and it's dated 18 May 2023. Unfortunately, the JP did not issue this case in April or March. Laurie, myself, and Antonio and the rest of the task team would have had better sleeping nights if this was the case. But yeah, this is the way that the law evolve, and we need to continuously do that. And I think Antonio touched on the fact that the next 2 years there will be a lot of amendments again. So if you can go down again, please. You can still go down. Thank you. All right, Rule 31. You all know Rule 31 as the rule that deals with, in general, all applications. Now, what is important on Rule 31, what we did is, if you look at the first sentence, subsection 1, it now reads that this rule applies to any application, including but not limited to. And then we've added, it's a bit vague here, but it says, and disclosure of documents. So the first important amendment to Rule 31 is we've added a wording including but not limited to. In other words, Rule 31 will, in our view, now apply to each and every type of application that lands up with the CCMA. So no more, but you did not need to follow Rule 31 because this type of application is not mentioned expressly in Rule 31. We now say including but not limited. So if I can give you a quick example, your Section 142A application or your Section 143 applications, those would also now be included in Rule 31. If you can just then go down, please. Right, I think Laurie also touched on this issue, crucial to Rule 31. We do not require an affidavit any longer. If you file a written statement, 100% in order. If you file an affidavit, it's also 100%, but we're not going to require that any statement must be an affidavit. And the simple reasons is that if you think about a lot of our users, they live somewhere where they don't even have access to a police station, attorney firms, etc. So they battle to get a statement, to take an oath in front of a police officer, etc. So that's the one reason. The other reason is simply in the 26, 27 years that the CCMA is in existence, as far as we know, there has never been a case where a person was taken to task for not telling the truth in an affidavit. And like Laurie also said, we can sort that out very quickly if during cross-examination, for example, it becomes apparent that the person is lying. You can still administer the oath if you're the commissioner. It's not taken away. But you will also recall even as the rule as it used to stand, also made mention that the CCMA had the discretion to accept a written statement and not an affidavit. So we have just extended that sub-rule that was already in place. All right, if you can go down, please. All right, important rule, sub-rule 8, applications may be set down for a hearing or determined on the papers. I think Antonia did that already with, for example, condemnation. There are 3 ways now. You can either, when a referring party sends in a case, it can be attached, the condemnation application can be attached to the referral. We can schedule the matter for a hearing, or we can decide a matter on paper. All right, if you then go down, please. All right, Rule 31B, how to apply for the enforcement of written undertakings. Addition, we've added an addition of an option that allows, my screen is not clear, but anyway, by means of a written statement instead of an affidavit also. So that's also for the Department of Employment and Labour. And then if you can scroll down, please. Rule 31C, maybe just to bring the viewers up to speed into the amount of work that went into Rule 31C. It's really hours of work. It started with a directive, it went to the rules task team, and then there was a huge debate even in the governing body on, if a party applies to have a matter re-enrolled, must it be served on the other party? How many days do you have, etc. So all those issues were built into Rule 31C, and you can see Laurie has placed a cross on Rule 31C. We're not going to follow it anymore. So Rule 31C, read it and then forget about it. Unless if there's another decision in the next few months. All right, you can go down. You can also go down there. Rule 32, confirmation that the decision does not apply when a matter was removed. We've built in Rule 32, sub-rule 2, which simply said that this rule does not apply where a matter was removed from the role. So obviously this one we're also not going to enforce or consider anymore, because there's no longer a removal from the role. If you can go down, please. Rule 34, interesting one, Rule 34, how to request an inquiry in terms of 188.8A of the LRA. There's a section 11. Now, the first amendment that we've built in here is that parties who request this can no longer pay per check. So obviously there's no more provision for that in South Africa, so we will only accept payment per EFT. If you can then just go down. Now, here's the fun part of Rule 34, according to me. There's a lot of case law, and I must say that Section 188, capital A, subsection 11, is in the law book for quite a while, although we haven't really used it in many cases. But what this rule is about is that there are instances where an employee can also make use of Section 188, capital A. And that is the case where he or she claims that there was a protected disclosure, a bona fide protected disclosure, and as a result thereof, disciplinary hearing was instituted, and the employee then sends in a referral to the CCMA. So our rule was outdated. It did not provide for that. And also our LRA, I believe it's 719 form, had to be amended also to cater for the instance where an employee asked us to conduct a Section 188, capital A, 11. Good news for the employees is that we will settle that matter. Bad news for the employers perhaps is that they will have to foot the bill at the CCMA, and that is not the CCMA that's saying that. That is the case law that refers to the specific Rule 34. If you can go down, please. All right, there's also case law that's not part of the slide. It's a recent case that came out and it relates to 37. Just quickly, those of you who want to write it down, Mamodupi versus Property Regulatory Authority. It's 2023 matter. And what the judge here dealt with is he gave us some guidance to determine our jurisdiction, whether we can in fact hold an inquiry by an arbitrator. So in essence, what the court there said is the employee must make a protected disclosure, and as a result of the protected disclosure, he must be subjected to some form of disciplinary inquiry. And that disclosure made by the employee must be done in honesty and in a bona fide manner. All right, I think that summarizes Rule 37. If you can then go down, please. All right, subpoenas. There are two major changes to subpoena. The one is the last part of the sub-rule, where we will now be able to send a subpoena per email. I think the CCMA must be the first forum to actually go this route. I'm sure it's going to be tested in the Labour Court, but we just think we're living in the 21st century, so let's do this by means of email. Then very important change to Rule 37 when we think about subpoenas. Maybe just to highlight this to the viewers, the office of the CCMA will receive an application for a subpoena, and then normally you have your regional senior commissioner considering whether he or she is going to issue a subpoena. Now, attached to the subpoena, there's normally motivation, or there must be motivation why you want a subpoena. But what we've built in now is even a further requirement or possibility of that regional senior commissioner who can now say, look, I've got the subpoena, I've got a motivation, but I'm really not certain whether this is, a matter where I must issue a subpoena, or is this just simply an attempt to misuse the system? So what we did now is we have said that the CCMA or the commissioner can ask the party requesting the subpoena for additional information, and then after that, that request and additional information may be opposed by the other party in terms of Rule 31 as well. So when you apply for a subpoena, keep in mind, don't make misuse of Rule 37. You're going to be faced with commissioners asking you questions. Why do you want this subpoena? And then you might also now going forward find that your opponent might say, you're wasting everyone's time. You're just misusing the system. The MEC has got nothing to do with why you were late on duty, just for example. So we've built that in because we've noticed there's a lot of misuse of subpoenas. All right, I'm almost done. If you can go down, please. Rule 40A, 40 capital A, payment of arbitration fee. Long and short here, all that was changed here is it must be done by EFT, and the CCMA must also issue an invoice if we ask an arbitration fee. Go down, please. Rule 41. I'm not going to go through all the amendments, but Rule 41 is the definition. If you can just go down, I just want to show you an important one for our users, perhaps. If you see there, number 11, sub 41 sub Rule 11 refers to employment law. Now, Antonio did that, and he referred to employment law, and we've then added what is the definition of employment law in terms of these rules. Those are, there's a lot of other changes, but not as material as these ones in Rule 41. Then if you can go down, please. Still down. So we've also added personal information, obviously the POPI. Antonio also touched on that when he started. I'm not going to read through that, but we defined what is personal information. Please go down. You can still go down. I just want to show the users at the end. If you can go down one more. All right, then at the end of the rules, we have Schedule 1. We have removed all the fax numbers of CCMA officers. We've added all the email addresses. We've rectified old email addresses. And we've also added the contact details of all your departments of labor. You will find that in Schedule 1. So my story is out. It's 17:30. I've made the cut. And the last part is going to be Laurie that's quickly going to deal with certain important forms that were also amended. Thank you to everyone. Laurie?
Thanks, Peter. So I've decided not to take up your challenge of the cold. I think sometimes you've got to bow out gracefully, and I've done that. So if you can keep your cold, thank you very much. All right. Yeah, so the general updates to our referral forms, mostly as is the POPIA requirements, putting in disclaimers, and then obviously just little bits and bobs here and there, typographical errors, etc. And then also sometimes the forms weren't so beautifully aligned to corresponding sections or subsections of the legislation. If you can just go down. We've got a whole list of them, by the way, so we can share it as well with our hosts, Cliff Decker, Hofmeier, just to make you aware of it. So our essential services, this is probably where it gets very important. Their Essential Services Committee run a very, very challenging unit, if I can put it that way. It's challenging because so much depends on the success and the smooth running of the essential services in our country as it does in other countries. So as they've been going along, they've noted that there are certain gaps in terms of forms, and these were two of them. So these are two new ones now. It's the 48B and C, and the one is when there's going to be strike action is to have some sort of request form to determine the minimum numbers of to be maintained during strike action. So that's the alignment with Section 72(2) of the Act. And then 48C is the other new one, application to vary or revoke a minimum service agreement. What we didn't have in this presentation is, and I was reminded by Advocate Bono before this, is that there's there's a certificate of outcome 712, the old original one, that's now been amended as well. And if commissioners are listening, please remember this, that the 712 now also includes a tick box where it can be referred for advisory arbitration or interest arbitration. And that's very much aligned to the essential Section 65, which limits the rights to strike and the recourse to lockout. And then the 712A, which is a brand new certificate of outcome, is solely designed for mutual interest matters where it relates to essential services. So that's more for our commissioners just to take note of. And if there are any other case management officers involved, to also take note of that, please. And if you could just go down, please. Yeah, then this one said goodbye to us. We say goodbye to the 717 referral of cost dispute. There's no, it's no longer required. So out with the old, and because there are no referrals about costs in terms of disputes about costs, shall I say. So that's gone. And let's see. Yeah, then 718 is your application to certify your CCMA award. And then 718A is the bargaining council award to make it eventually to have it enforced. So the form in the past didn't say that the person applying or making application in terms of these sections must serve it on the other side. So now we've fixed that anomaly and they now need to do so. So that's for that. And then just before I get to Q&A, just something that's in terms of Schedule 1 that I just want you to notice, please don't refer anything to the head office email address. It'll lie there and get older and older and older. We've taken that away. And if you're also wanting to refer matters, you need to use the official email addresses or any other portal in Schedule 1, because if you don't, you can't blame us if your matter just gets very old and nothing happens. So please just take heed of that. Thank you. That's my lot. So we've ended a little earlier, but it's all good. And I don't know if Imran, if you willing to take over from here. Thank you.
Thank you very much. This has certainly been a very enlightening presentation. I wanted to sum it up with one word, to say excellent. Being somebody that appears in the CCMA quite often, just to get an explanation from senior commissioners such as yourself in relation to some of the background information and how you see the rules practically play out is very valuable. So we really appreciate the time. We appreciate the efforts on the part of the CCMA, making yourselves available at a senior level to come and talk to a wide audience. What was very interesting, particularly for me, was to see the 1 month CCMA rule that Senior Commissioner Venter refers to. Excellent. What it does tell us is that the rules, as Commissioner Mudali indicated, is a living document. So it's indicative of an obligation on the part of the CCMA to give effect to changes to the rules as required by the LRA, but also goes a long way to show that there are challenges to the rules in the CCMA and that the rules are being interpreted by the Labour Court and the Labour Appeal Court. And what's significant for us is in a constitutional democracy is to see a state organ such as the CCMA giving effect to that practically. In the 1 month CCMA rule in relation to removals is a classic example of that. Commissioner Warwick reminds us of the importance of the ESC, particularly in the current environment in which we live. The ESC is a very important, I don't want to call it an adjunct of the CCMA, because having been involved many years ago in an appeal to the SCA with the ESC, the importance of the ESC was noted by the Supreme Court of Appeal, where it sits in relation to ensuring essential services designations and minimum services agreements and the like, to ensure that the right to strike is properly protected, and that labor relations in that particular industries or sectors are properly dealt with. It leaves me on the basis of saying again, thank you very much for giving us the opportunity at CDH to host this presentation with you. I'm sure I'm not going to see you in 2 years' time doing this. The next time I see you, it's going to be begging for a postponement or alternatively asking for a directive, but it's too late in the evening. I know that the CCMA closes at 16 hours 30, so we're not going to ask for a directive. Thank you very much. Senior Commissioners Mudali, Warwick and Venter. And if the viewers have any specific questions, please try and drop them into, or continue to drop them into the comment section. The CCMA has undertaken to pick up as many of those questions and to come back to viewers. Thank you very much.